We're here continuing our study of Lesson 17. This is the second and last segment for Lesson 17, Remedies for Breach of Contract. So where are we? We've studied monetary damages. We know that there are several different types: compensatory, consequential, punitive damages recoverable in tort law but not in contract law, and nominal damages, the $1. We've also studied that liquidated damages clauses might exist, as often happen. Sometimes in construction contracts, it might say, for example, if you're late for every week that you're late, you're going to owe us $5,000. Instead of having to compute the actual amount of damages, which might be how much did we have to lease property for, things like that. We always have to ask, is a liquidated damages clause a penalty? There's two questions that have to be answered for that. But now I want to discuss equitable remedies. Basically, this is where the judge is going to order something that occurs other than monetary damages, other than just saying, here's money, I'm going to give you something else. And we're going to study specifically specific performance, injunctions, and restitution. Specific performance is only available if monetary damages are inadequate. And it's very rare to see this when you buy something from a store, because generally speaking, you can go out and get a replacement for that good. You might have to pay a little bit more, and in that case, that's your damages. But in the case of rare items or unique items, such as, for example, you're contracting for the delivery of a painting by a painter, a sculpture, a rare book, or a coin, those goods are very unique. So, for example, if you contract and say, I'm going to buy this rare book for $1,000, and that dealer doesn't deliver that to you, you could sue them for specific performance, assuming there's no other available book of the same type out there, the same condition, the same author, the same edition that's out there. That would be a rare book, something unique. For personal service contracts, specific performance is extremely rare. For example, let's say that I contracted to sing for you, and I then refuse to sing. Could you get a judge to order me to sing? And the answer is no, for several reasons. One is, obviously, you may not want me to sing, which we'll disregard that for a minute, but one reason is involuntary servitude. We don't like, as a society here in the United States, to compel people to do things that they don't want to do. We don't want to compel them to perform services for another individual under some type of contract. We've discussed this before in business law. Basically, at the time our country was created, a lot of the people who migrated over here, especially from England, entered into 7-year contracts in which they basically obligated themselves to perform services for another person for a period of 7 years. That other person paid their way over, and they bought themselves into basically 7 years of slavery under these contracts. Slavery has been outlawed under the 13th Amendment to the U.S. Constitution, which was made applicable to the states under the 14th Amendment and due process. So we don't like to compel people to perform anymore. This is not the case of several hundred years ago when someone could have been compelled to perform. It's also very impractical to monitor personal service contracts. If you were to say, if I was told Alfred State, for example, I'm not going to teach anymore, I'm going to breach my contract, I'm going to leave, could they get a court order to force me to teach? Well, assuming the court would do that, it wasn't involuntary servitude, and that might be one reason they don't do it. There's another practical reason. I could just stand up in front of the class and not say anything. I could basically be the worst teacher on earth, even worse than I am now. I'm not, oh my gosh. So the result is, if you're compelling somebody to specifically perform, it's very difficult to monitor that performance. At some point, a court would actually have to come in and monitor how that is being performed. Otherwise, you're going to be back and forth to court almost every day. As a result of that, we don't like to compel people to perform their personal services on the contracts. Contracts for the sale of land, specific performance is usually granted, and the reason is each parcel of land is unique. Now, for example, suppose there are two side-by-side lots on a street in Alfred. One is right next to the other. They both have equal square footage. They both have very similar views of the countryside. They both are level. They both have the same terrain. They both have the same amount of trees on them, and the trees are actually in the same location and all of that. And the both lots are up for sale. And let's say you go and contract for the purchase of a lot, and the seller enters into that contract with you. And then you go to closing, but the seller doesn't want to convey that property to you. Can you compel specific performance? Even if the lot next door is available for the same price, and you can easily close on a contract for that lot and buy it from another seller instead. And the answer is yes, you can compel specific performance in that case, because even if there's just a slight difference, each parcel of land is unique. As a result of that, specific performance is probably the most common instance of when specific performance is entered into by courts, is when somebody tries to back out of a real estate contract. Another equitable remedy is rescission and restitution. Basically, rescission means we're going to undo the contract. We're going to return the non-breaching party to the position he or she occupied before the transaction. This is available if there's been some type of misrepresentation, fraud of some type, mistake perhaps, duress, or there's a failure of consideration. All of these things we've studied in the past. The rescinding party in this case must give prompt notice to the breaching party of the fact of rescission and any demand for restitution. Another equitable remedy is reformation. This is when the parties have imperfectly expressed their agreement. It's available where there's fraud or mutual mistake, where the parties agreed verbally, but when they reduced it to writing, they made a mistake. Or another common case, and perhaps the most common case, is when there's a covenant not to compete that's too broad in terms of either the time or its geographic areas. Courts in the state of New York will reform that contract. As we know, generally speaking, courts in New York State will reform a contract so it lasts no more than 2 or 3 years, and the geographic area must make sense. If somebody was working only in one county, for example, with customers, then that geographic area might be limited by the court to that one county. Reformation is not available if in some states for these non-compete agreements. In some states, they'll just throw the entire agreement out. And there are even a few states out there that don't enforce non-compete agreements in most cases anyway. There's a lot of variance of state law, but here in the state of New York, covenants not to compete will be reformed by courts if they are too broad. So let's take some examples to apply all of these concepts. Bob contracts to buy 1,000 metric tons of wheat from Joseph for $300 a ton. We'll assume that this contract is in writing. It's a contract for the sale of goods. We want it to be enforceable, therefore, because it's over $500, it needs to be in writing. Joseph fails to deliver all of this wheat. That's $300,000 of wheat there. The market price of wheat has risen to $400 a ton at the time Joseph refuses to deliver. Perhaps Joseph, trying to be smart, was selling that wheat to somebody else instead. The question is specific performance available for Bob? Can Bob say, hey, here's the $300,000, I want a judge to order you to deliver that wheat to me? The answer is no, because Bob can go out and get replacement wheat in the marketplace today. He might have to pay more for it, but he can recover monetary damages, those compensatory damages for that. How much would he recover? Likely to be $100,000 plus if he had any expenses incurred in connection with that, such he had to hire a broker or something, and perhaps he could recover consequential damages depending on the circumstances. So in this case, specific performance, an equitable remedy, is not available because monetary damages are sufficient. How about this? Kevin pays Leah $10,000 to design a new kitchen for him. The very next day, before doing any work, Leah calls Kevin to say that she has taken a position with Running World magazine and won't be able to do the job. Can Kevin compel Leah to specifically perform this contract? Can he force Leah to design a new kitchen? And what is Kevin entitled to at this point, if he can't? Well, the answer is we're not going to compel specific performance of a contract for personal services. All right, so we can't get specific performance here. What is Kevin entitled to? Let's say Kevin goes out and hires another designer, but now it costs $15,000 for that designer. Is he entitled to more? Not necessarily, because the fees charged by designers very much vary depending upon their skill level, their experience, and their reputation. So Kevin may have hired, in essence, a designer that was a much better designer than Leah, and he would have a very, very difficult job proving that he hired the same type of designer in that case. Because the damages, you cannot get an equitable remedy in this case, and because the damages are very difficult to compute, in fact, they may not even be able to be ascertained because of this inability to compare services, it's likely that Kevin would have no damages. And this is a risk of doing business, that another party will not do business with you, and therefore you need to go out and get a replacement for that. And the fact that you might pay more in some cases, you may not be able to recover that in cases where the services that are provided involve skill that varies. Now, another topic relating to remedies is the fact that you can file a lawsuit and you can seek different remedies in a lawsuit, but then elect one remedy at the end. At the end of a trial, typically at that point, the party who is suing has to elect which remedy they pursue. The complaint can ask, we want specific performance, we want monetary damages, but then depending upon what is proven, the facts that come out in the case, then the plaintiff in that case, the party who is suing, can then decide which remedy to pursue. Maybe they say, well, we've proven monetary damages, or we think we have, therefore we're going to pursue that. Or if they've proven that monetary damages are not ascertainable and that a specific performance is available in this case, perhaps that's the remedy. Now, relating to the sale of goods, this doctrine that you have to elect remedies has been done away with. That's because remedies in the sale of goods contracts are cumulative. But realize that in the sale of goods, unless it's a unique good, it is very rare to see an equitable remedy given. Typically, you're talking about monetary damages in this case. So it's very difficult in sale of goods contracts to see a duplication or a cumulative effect of remedies. Here's an election of remedies example involving real estate, not the contract for sale of goods. Adam purchases land from James for $150,000. Adam makes improvements to the land in the amount of $10,000. And then while making these improvements, Adams finds out that James had a landfill on the property that was not disclosed in the contract. Adam has been victimized by a misrepresentation in the sale. Now at this point, we don't know if it's an innocent misrepresentation or an intentional misrepresentation. Doubtful it's a negligent misrepresentation. The facts don't seem to fit that. The possible remedies available to Adam are to rescind the contract and to seek restitution, to basically get paid back what he has put out. Damages for breach of contract, what is the cost of removing this landfill debris? It might be tens of thousands of dollars or a lot more. And possibly, if it's an intentional misrepresentation, you could sue in tort for punitive damages. Now, can Adam rescind the contract and sue for damages for breach of contract? No. Under the election of remedies doctrine, you have to elect either an equitable remedy or seek damages. You can't do both. And the question in this case is damages able to, basically are damages sufficient. Remember that parcels of land are unique. Therefore, Adam could elect to seek rescission and restitution, an equitable remedy in this case, and he could get out of it, or he could sue for damages, either one, but he can't do both. Now, if he elects rescission and restitution, he wants to get out of the contract. One of the questions is, well, he's going to get his $150,000 back. Is he also going to get his $10,000 back? That varies from state to state, and it depends upon the facts and circumstances. One of the questions a judge might ask is, did that expenditure of $10,000 improve the market value of that land by $10,000, or what amount did it improve the market value of the land for, if any? It may have been an improvement to the land that would have only benefited Adam if he went through with some specific type of building, or for example, and has no real value to anybody else, in which case he may not be able to recover that $10,000 in some states. But in other states, the courts would allow the $10,000. Don't know what the law here in the state of New York is. It varies, again, from state to state. There's no real consensus there. But generally, remember that in this case, he can't rescind the contract and also seek damages for breach of contract. He can seek rescission and restitution. The question in this case is the amount of restitution. And again, the laws vary in that regard. Now, it is possible to breach a contract and then for the other party to waive that breach, basically to accept that breach of contract. And if that waiver occurs, then the party, the non-breaching party, cannot sue for the breach of contract. The waiver keeps that contract going. And generally, it does not operate to waive other obligations on the contract. The exception, however, is there's a pattern of conduct. If there's several waivers that occur, then subsequent waivers may be inferred, at least until for a period of time. To get around waiver of breaches, there are lots of non-waiver clauses. These prevent the party's course of conduct on the contract from resulting in the loss of the ability to enforce that contract. An example of a non-waiver clause includes this: the failure by one party to require performance of any provision of that contract shall not affect that party's right to require performance at any time thereafter, nor shall a waiver of any breach or default of this contract constitute a waiver of any subsequent breach or default or a waiver of the provision of the contract itself. Very common non-waiver clause that you see in contract to get around this problem of, well, somebody breached the contract, but I'll let it go this time. We have to ask some questions as we analyze these waiver breach cases. Has a breach of contract occurred? Has the injured party waived the breach in some way? And has a pattern of conduct occurred that is inconsistent with the contract language, in which future similar breaches might also be deemed to be waived, unless the contract language has a non-waiver clause, which again is very common. So here's just an example. Kelly is required to make monthly payments to Catherine under contract. Kelly only pays, instead of monthly, she pays every other month. Catherine deposits the contracts as they received. This continues for a year. Did a breach of contract occur when Kelly failed to make a payment? Yeah, the first time, yes. Could Catherine sue for breach of contract after the first non-payment? Yes. After a year passes and this pattern of conduct occurs, Was the breach of contract waived? And the answer is likely yes. Can Catherine go back and recover the payments not made? Perhaps not, although it depends. If it's a promissory note that requires a certain sum to be paid, and these are monthly payments of this fixed sum that is due, those payments might be added on to the end of the term of the promissory note and be paid, basically extending the period of time for payment. But we also have to ask, is a non-waiver clause present? If a non-waiver clause is present, then yes, Catherine can go ahead and sue, even though she has, in essence, uh, waived by her actions prior breaches. It doesn't excuse the next breach. Now there are clauses that limit liability in contracts. Some of these are called exculpatory clauses, under which no damages are recovered. Surprisingly, these are enforced unless it seeks to limit damages due to fraud, some type of intentional tort, which results in some type of injury, illegal acts. You cannot waive your liability if you perform an illegal act or an act contrary to public policy. We also have limitation of liability clauses, in which basically says we're not going to be liable for all of these other things. Those are generally enforced unless it's an adhesion contract, basically in cases where unconscionability occurs. Here's an example of a limitation of liability clause. If you were ever to buy a computer from Dell, this is the language out of the Dell computer contract. Dell, including Dell's parents, affiliates, officers, directors, employees, or agents, does not accept liability beyond the remedies set forth herein, including any liability for the computer device not being available for use, lost or corrupted data or software, or products sold through Dell's software or peripherals division, or the provisions of services or support. Dell will not be liable for lost profits, loss of business, or other incidental, indirect, consequential, special, or punitive damages, even if advised of the possibility of such damages for any claim by any third party, except as expressly provided herein. That's a valid limitation of liability clause. So if you order a computer from Dell and you expect shipment has been promised, for example, next Tuesday, you don't get your computer, and because of that, you can't get a lot of work done. Dell's not responsible for your lost profits or anything like that. The only thing that they're required to return if they don't deliver that computer to you is basically what you paid for it. And if they deliver the computer late, within reason, they can do that. If it becomes unreasonable in terms of delivering, you can always cancel the contract at that point. But that would be very rare in terms of that happening. How about this example? I sell you my iPhone, which, as you know, has this incredible selection of pre-1990 music on it. But I state to you in our contract there are no warranties express or implied. I am not responsible for your extreme excess pleasure in listening to all this great pre-1990 music. In fact, I am not liable to you for any reason whatsoever. That's an exculpation of liability clause. Upon your receipt of the iPhone, however, you discovered that the music that I stated to you was on the iPhone. I had deleted it before I delivered it to you. Can you recover damages from me? Can you rescind the contract and seek restitution? Or could you seek specific performance? In other words, could you compel me to deliver the music? Let's take the last one first. Probably not. You probably could not compel me to deliver music, basically take the iPhone and download songs for you, all right? Because that would be performance of a personal service. And as we know, the courts are not likely to order that. How about damages? Without all this music, you could go out and find that music and pay for it. Yeah, you could probably sue for damages. Could you sue for rescission and restitution? This appears to be a case of fraud, and the fact is you could sue for rescission in return of the purchase price to you. That would be one of the remedies that you're allowed. So you could either seek, in this case, damages or rescission and restitution. So just a reminder as you study for the exam on all of contract law, prepare excellent outlines. Go through the examples that are contained in the PowerPoint slides, also the examples that are contained in the textbook. Go over them with your outline. Make sure that you're getting the right answers. Add to your outline when you don't get the right answer. Make a note to yourself. Even write, if you have space available, write down some of the examples in your outline. Because similar examples might appear as the hypothetical fact situations on the exam. Also remember, you need to understand and know all of these concepts in contract law that we've studied over the lessons 2 through 17. Uh, you don't have to memorize them, that's why you have an outline, but you still need to know them and be able, that knowledge of all these concepts is going to enable you to spot the issues. And then delve down, and once you spot the issue, you can turn to your outline, you can go through the steps of analysis, and hopefully come to the right conclusion as you apply these legal principles and their exceptions to these fact situations. Good luck preparing for the exam.